will be time for questions at the end of this presentation. It's not really a presentation, it's just really a class. So, okay, it's 8 o'clock. The class has officially started according to me. So here's what I'd like to start with, right? So why am I doing this? So this COVID pandemic has kind of taken over a lot of our time, has changed the way we're looking at life. So if I can use this period to basically talk to you about stuff that I know, I can probably find a way to kill time. And given that there is a lot of time to kill, given that I'm a Mumbaiker, thanks to this mandatory work from home, I have found that I have about 4 hours a day that I used to spend on commuting. That's now just literally been made available to me. Uh, do you think we should wait about 2, 3 more minutes to see more people will join in? Because people are still seem to be signing in. I think let's give them time for a few more minutes. So let me just give you a background till then about why we're discussing what we're discussing, right? So the reason I felt that we need to discuss this in detail, as in the historical introduction to the law of India, is because the law of India is a highly complex system of law. So it's very easy for you to look at a textbook and say, no, India is a common law country because it was a former British colony. But it's not as simple as that practically. So now I'm just going to now open my screen so you guys can start seeing this little presentation I have prepared for you chaps. This presentation should now be on your screen. Now, thanks to the way this system works, I'm not going to be able to see your chats while this PPT is on the screen, but such is life. All right, so let's begin the class. I think we've given enough late Latifs. Oh God, 2 more people coming in. So this will have to be done every time I invite people in, I guess. All right. Okay, great. So let's begin the lecture. This is a historical introduction to the law of India. So what we will cover today is a short introduction to the evolution of legal systems across the world, the development of common law after 1066. In particular, I will try and explain to you why 1066 is an important date, not just in the history of England, but also in the history of India. India, the various parts, places, and jurisdictions as they existed in the year 1857, that is when control passed to the crown. The various Government of India Acts and the codification and transposition of common law into India and its consequent displacement of other laws. Now, this is the primary motive behind my lecture. It's so that people understand what we mean by displacement of laws. So I want you to, before we do anything, let's go to Sumer. Now, Sumer is a civilization we don't normally talk about, but it's one of the oldest civilizations in the world. This is a contract for sale of immovable property in Sumer that from the year 2000. Like I managed to find it online, translated from a cuneiform tablet. But if you look at this, what it says is this chap called Sini Ishtar, who is the son of Ilu Irubi and Appa Ili, his brother, have bought 1/3 shar, which appears to be a unit of land, with a house constructed next to the house of this person, next to the house of this person, and arable land next to the house which fronts streets, the property of this fellow, the son of this fellow, from this fellow. They have paid 4.5 shekels of silver, the price agreed. Never further shall any claim be made account on the house of Manani. Now, by their king, they swore the names of 14 witnesses and a scribe follow in the tablet. Month Tebet in the year of the great in the year of the great Karashamash. Now, what basically is this is that why this was important to me here was this. I wanted to look at 3 key things here. One is the way the property is described. If you look at a sale deed today also, you will see that property is described in a similar manner as it was in 2000 BC. What surrounds the house? Where is the house? Also, the key element here is consideration, right? So the contract records that there was a consideration between the 2 parties for which the sale of land occurred. And the third critical thing is, never shall further any claim be made on account of the house, which means that what? The seller of the house also releases all claims that could be there in future with regards to the house. If you look at a sale deed today, right, like a regular sale deed today that you find, one second, just hi, welcome, late Latifs, welcome to the call. All right, so we're discussing a sale deed from Sumer from the year 2000. So BC. So what you will see here is that you will see the three key things that I want you to see. I want you to see how the property has been described. I want you to see how the parties have been described, how the consideration has been captured. Further, critically, this sale deed from Sumer also releases claims. The language should have and to hold forever that we find in conveyancing today is not a new thing. It's been around since 2000 BC. Further, in witness before, there are 14 people witnessing this and a scribe who's recording this. The scribe in Sumer performed a role that a notary would perform. So what would happen is these agreements, these sale deeds in Sumer would be recorded on clay tablets and by these scribes and in the presence of witnesses. And then they would be deposited in the temple. This was temple culture in 2000 BC. Luckily, we have texts surviving from this time because the Sumerians wrote their texts on clay. So when invaders came and burnt the place up, all that happened was the clay hardened and became even more readable as opposed to still being wet. So we still have this, but this is something that's important for us to see from a historical perspective, that what we have been doing as lawyers is something that's been around for about 5,000 years now. We're an incredibly old profession. You've got this scribe here whose job is to write down the legal contracts and explain it. So this is a legally enforceable sale deed from 2000. Now, let's go into the period after this and the other parts of the ancient world post the collapse that we saw during the Bronze Age, right? So we've got Greco-Roman legalese. And why am I calling it this? Because most of the philosophical developments that you will be dealing with in law, right, come from Greco-Roman thought, right? This legacy is something that still continues today. Like Greco-Roman words like democracy, for example, are found in our constitution and have found in constitutions across the world, right? Now, Greece had many city-states at this time. The Greek peninsula had a lot of city-states, right? And each state had its own weird system of how it would govern itself. Usually the rules were very simple. Like there was only one class of people who were important, and these were men who weren't slaves, right? So when we are talking about Greco-legal thought, we need to basically understand that when they mean all people, they basically mean men. Because if you're a woman, child, or a slave, you are not included within that definition of people as far as the Greeks were there. But they did give you a lot of interesting models. Now, one interesting model is the democracy of Athens, which actually has a philosopher who has written down the constitution. Now, when you talk about the constitution of Athens, you don't really talk about it like you talk about the constitution of India, right? There is no hard book that you pick up and then you look at it and say Article 1, India shall be a union. No, that's not how this works. So there were philosophers who were traveling the Greek states who were writing about life in these Greek states. And one of these key things would be Solon. The philosophers would be Solon when he wrote about his constitution of Athens. And that provides us with a lot of insight about Athens, right? Athens is the world's oldest functioning democracy at that point of time, right? By democracy, I mean that all people, in which in this case is men who are not slaves, had the right to vote on the laws, and this would be done at the assembly. A interesting fallout of this legal system is that trials were also conducted before the assembly. And infamously, the trial of Socrates, which Plato records in also known as the Apology of Socrates, you see that a person could be brought before the assembly and charged with a crime. And then they would present their defense after being prosecuted, and then the assembly would vote on whether they were guilty or not, and also the question of sentence. Now, Obviously, the execution of Socrates didn't really make Plato very happy. So when you look at Plato's Republic and you look at the laws that Plato writes about, right? Plato takes a very dim view of this democracy. And you can see this evolving in the Republic by Plato, in which he talks about a rule of philosopher kings and a rule by enlightened personalities, right? But but to contextualize it, you have to understand that his teacher and friend Socrates had been killed by democracy. And that is something that you also need to understand when you look at Plato's critique. But these are two things that you should read: the Constitution of Athens, and you should read the Republic by Plato, because that will give you an example and a good working knowledge of what were the conflicting theories about the role that government had in everyday life at that point of time. One was a more popular view in which that there was a consensus and society would act through the majoritarian concept, which you would see in Athens. And then you would see Plato's critique of these systems as being one that doesn't move society to a higher level. Now, when you see that, and you also look at the constitution of other states in Greece at that time, for example, the constitution of Sparta, in which Sparta actually had two kings for the longest time, right? And the roles of the two kings would be divided, and then it gets into conflict when it becomes one king in Sparta. So, the reason we're discussing this is because these principles move further once you go to Rome. Now, Rome is what we consider to be the great successor to Greek civilization. It's not what we consider it, the Romans considered it themselves, right? So, Roman mythology, Roman architecture, Roman enlightenment is basically the Greeks on cocaine. Right, it would be really fun to see that the empire would finally survive in Greek, and that the Latin period of the Roman Empire would be a short-lived period if you look at the broader 2,000-odd-year-old history. But Rome's legal practice is strange because a lot of that legacy still survives today. And as a lawyer every day, right, I find that I'm still dealing with Roman concepts. And, and why is this the case? One, because Rome was the first major Western empire. And when I mean by empire, I mean a proper empire with administrative divisions, with a legal system and administration that needed to be carried out. This is very different from a bunch of local kings pledging their allegiance to the high king, as was the case in other parts of Europe and the world at that time. Rome was an empire in the strictest sense, like the Iranians were, the Persians, the Sassanids, the Egyptians. So, but since a lot of the Eastern legacy is now lost, what we find is that when we're dealing with the history of the world, we end up having to interact with Rome. Now, why is Rome fun? Rome is fun because of the way they did trials in Rome, right? So you know how trials used to happen in Rome? They used to find, if there was a dispute, you had to present a complaint. And this complaint, after presenting the complaint, they would appoint a judge, right? And then one person would go make their case to the judge, and the defendant who was called to answer the case would also be brought before the judge to make their case. They could bring witnesses, after which that adjudicator who was appointed would render a decision in accordance with Roman law. Now, this is very similar to what happens today. So what's happening today is something that's been going on for about 2,600 years now. Is the adversarial process of trial in order to determine facts. Now, of course, there were corruptions of this system, and in the medieval era, you find that all of this is lost till Roman thought is rediscovered. As in, there are many historians who consider the Enlightenment to be nothing more than a rediscovery of Rome, right? But if you look at this, you will see that in the medieval ages, this moves to trial by combat, and trial by other systems, where you would go underwater, and if you could survive, you would be considered not guilty. Not very scientific. But here you've got these guys, right? And this judge could also, in some cases, you could bring cases before the assembly of the people in Rome, very similar to Greece. But what you see here is, you see that the main core system is still that you bring your case before the people, either via their courts or the assembly, and then the dispute is resolved in accordance with the laws. So in Rome, you've had people who've been tried by the Senate, who've been tried by magistrate, another word that we use in India right now, who've been tried by the tribunes, who are also, well, called tribunals, another word that you use uh, today. Many of the writs, the language originates at this point, but even though the concept doesn't, but the Roman distinctions of things like actions in personam and actions in rem, by what we mean that private acts and public acts, right, still continues to survive today in a large way. So when you enter an Indian courtroom, strangely enough, you're going on a Greco-Roman legacy that's been around for many, many years, administering justice. All right, now I would classify Roman law into two periods, right? The period of the Roman Republic, and then the Western Roman Empire, and then the Eastern Roman Empire. Now, as far as the Western Empire was concerned, the law was codified into 12 tables, as in 12 tablets of stone, which were put up in the public for the public to read at the forum. Now, these 12 tablets contained the laws of Rome. Cicero was a famous lawyer from ancient Rome and was also, like most lawyers, fundamentally incomprehensible, right? Uh, had a lot of very interesting things to say. He said that the 12 table seems to me absurdly to surpass all the libraries of all the philosophers, both in weight of authority and the plenitude of utility. Now, this was because the Roman law was getting very complex at the time, because Rome, unlike other places, also had law by statute, right? The Senate could pass decrees, tribunes could impose measures. There was a lawmaking process at the legislative body. The Roman Senate and Assembly are a very complicated legislative body whose history anyone who enjoys the history of politics should read. Just read it, not for anything else, but just to enjoy the intrigue and the sheer complexity through which these guys were making their laws, which finally included, after the law had been passed by the Senate, it would go to the Assembly, and after it had been passed by the Assembly, you had to take the hard copy of the law and keep it in the treasury for a record. Now, while the Romans were very great about creating records for these statutes, they got very complicated after a point, so they dumbed it down into 12 tables in order to make the law more accessible. The trial system I described earlier still was continuing as normal, but now run on the 12 tables. But here's the issue, right? Judgments by these individual adjudicators, we can't find them. We can't find them, as in it's not very easy to find. You get very rare things. As in the decision is rendered, the decision is enforced, but why the decision was arrived at or how the adjudicator made his decision do not survive. The next judge would come completely blind to what the old judge had done in a similar fact and would do this as well. So this is where you see this idea of a rejection of precedent coming from the Roman legal system. Now, on the East, on the other hand, after this split, this is Byzantium. The Roman Empire is being run from Constantinople, and Justinian is the king. So Justinian, now this is about 400, 500 years after the golden age of the Roman Republic that I just described, with this complex legislative system and all. Justinian rules a much smaller uh, empire compared to the Western Roman Empire and the East combined. He rules in the East. And in the East, Justinian looks back at the glory of Rome and says that I also want to create a system like this. So what Justinian does is he codifies the laws into his codex, also known as the Corpus Juris. Now, this Corpus Juris, most people think is just a set of the laws, but it's not. It is also detailed guidance on how the laws are to be applied by the judges, right? So Justinian not just assisted in the compilation of the codex. What Justinian did was he expanded it to include interpretive directions, right? So the law in its most minutiae is covered in the codex, which is interesting again, because this is a forerunner to modern civil law systems. Like Napoleon from France later would take inspiration from this to make the Napoleonic Code, but that has nothing to do now with the history of India, because this is where this our link with Rome rather stops. And now we move to our link with the other parts. But two things that we need to examine, because when we come to the history of England, and the law there, this thing has to be examined, and especially also with regards to the law of India. One is the role of religion. So you will find that in most societies, law often has the sanction of religion. Now, when you read legal history of ancient India, you will be told that the laws governing ancient India were Shastras and the Dharma Shastras. Some people will come and say it's the Manusmriti, some people will come and say it's the Vedas, but the authority to govern was always a religious authority, right? So after the fall of Rome, what you have is the evolution of the Roman Catholic Church. The church was a key influencer of development of law in Europe after the Roman era because the church saw itself as the successor of Rome. For example, the Pope till today is still called the Pontifex Maximus, which is the Roman designation for the head of the Supreme College of Pontiffs. Strangely enough, his predecessor to the role of the Pontifex Maximus of Rome would have been Julius Caesar. uh, One of his historical predecessors. So that is the seat that the Pope sits with, the papal authority extended across Europe. So the court made its own, the church made its own system of ecclesiastical court and ecclesiastical laws. A lot of the time you were brought before church courts, for example, for things like blasphemy, or for church libel, which is when you try to change the doctrine of the church. Luther was prosecuted under these laws and brought before these ecclesiastical courts. The crown still had its own courts, as in kings had their own courts, but these jurisdictions largely overlap. For example, in 800 AD, if you wanted to get a divorce, you couldn't in Europe because the Roman law, Catholic Church said no divorce, right? But you could apply to the Pope for a one-time exemption and get a divorce because the Pope was the sovereign as far as those matters were concerned. Even the kings ruled under the authority of the Pope. Now, with the dawning of Islam, you have something even more different. Like, unlike the Catholic Church, Islam comes with its own sanctioned legal system. And the sanctioned legal system is not just restricted to religious matters, but extends over to secular affairs, such as the conclusion of contracts and wills and other matters, right? So, Islam comes with a legal system on its back, and this legal system is largely of Semitic origin. So, it goes back to the laws of Moses, which again found themselves in the laws of Hammurabi in Sumer, and it comes in a large thing. And when you have the Islamic conquest of India, right, that is the first time you begin to see a displacement in the law of India. So that's why you find this instrument called a firman, which is a Turkish instrument, but which is essentially the equivalent of an executive decree. Firmans could be issued by the sovereign or by persons who had the authority of the sovereign. Firmans are a legal instrument that you will find in pre-British India. Often firmans were used for things like the land grant of land, to provide for certain freedoms. Firmans are an example of how executive authority was wielded. That's one. Number two, to look at it in terms of the Islamic conquest of India, is that when the Mughals came, right, they began to allow this displacement to happen in some areas, but in some areas this displacement did not happen, right? So if so let me just explain this in a simpler manner, right? We have Hindu personal law today because the Hindu law was left untouched by previous Islamic administrations. So, if you can say that Hindus have their personal law today, right, it is because the law was not displaced. Hi, is someone saying something? Hello? Hello? Hi, there's some noise on the call, yeah. Can everyone just put themselves on mute? All right, great. Okay, that noise has stopped now. All right. So now what I'm largely saying is that there was this displacement. So what you see is you see that there are two legal systems that exist in Mughal India, right? One is if you're a Muslim, and one if you're not a Muslim. Now, there is one primitive view that you can take and say that this would mean that Hindus and Muslims were not treated as equals, right? But there is another view that you can take, that a foreigner did not want to impose their own rules on the existing native population without their consent. Now this argument becomes important when I talk to you about what's going to happen in the future. But with Islam, you've got this amazing system, legal system, and in the Islamic world, because of Islamic law, what you're having is because Islamic law is creating this unified legal system across the Islamic world. What you then end up with is frictionless trade in not just goods, services, but also ideas, right? Ibn Battuta was able to travel all the way through the East into China comfortably, and he was just a trained qazi or an Islamic lawyer, right? And his logic was that if I'm an Islamic lawyer, I can find a job anywhere, right, in the Islamic world. Uh, it also meant that firmans on one side were honored on the other side, and because they all function under the same authority. The unique thing about Islamic administration is sultans, right? Like kings in Catholic Europe, sultans too function under the religious authority of the caliph, whoever was caliph at the time. Now, this was the case in India for all the sultans till Babur, who was the Mughal, declared himself emperor, not sultan, right? And because he was an emperor, Babur was no longer bound by the authority of the caliph. So Babur would give the sanction for the Friday prayer. Now, this becomes an issue again during Victoria's administration of whether you can have the Friday prayer in Islam with a non-Muslim monarch. But Babur declared himself emperor. And another link to Rome is that the emperor of India was also called the Kaiser-i-Hind, Kaiser. In Latin, the C is pronounced as K. So if we were going to talk about Julius Caesar, you would call him Julius Kaiser, right? The Mughal emperor was the Kaiser of India, the Caesar of India, just as the Tsar of Russia was the Kaiser of Russia, right? And the German king was also called Kaiser. The title of Caesar was a title that all Indian monarchs bore after the Islamic invasion and the establishment of the Mughal Empire. All monarchs in India have borne the term Kaiser till George the Sixth, who was the last king and emperor. They've all been in the Indian things been styled as Kaiser-i-Hind. I know it's not something that most of you would find relevant or enjoy, but I thought it was a fun fact to share anyway. Now, 1066. Why is England's royal motto in French? Now, in 1066, there's this place in England where they had a battle, and this was called the Battle of Hastings, right? And William, who was the Duke of Normandy, defeated the Anglo-Saxon King Harold. Now, this all happened because Edward the Confessor died in 1066, and there were disputes about his heir. The English kings at that time elected Harold to be the High King, right? But after the Battle of Normandy, after the Battle of Hastings, what you noticed is that William the Conqueror, who was the Norman, becomes the King of England. Now, this becomes important, right? Because England till now is Anglo-Saxon and the Normans are French. And so William sits on the throne, and William, frankly, can't administer the country because heck, he can't speak the language, right? So in about after taking care of his nobles and his soldiers and everyone, in the year 1085, William commissions a book called the Domesday Book, which is completed in the year 1086. Now, the Domesday Book was a record of all the landholdings in England, right? And the authority as they existed at the time of Edward the Confessor. Think about this. He comes in 1066 at the end of the reign of Edward the Confessor, waits for about another 20 years, and then does a national register of landholdings. Till the 1800s, this would be the most comprehensive document about this. And the reason we call it the Domesday Book is because if your entry was not on the book, the law didn't recognize your entry. The idea behind this book was then William would then see, this is how much land I have, this is how much land is available with the nobles, right? But because the administration was in chaos for these 20 years, then he began to issue writs. Now, a writ is an Anglo-Saxon concept, which is a direct authority, direct order from an authority. That is a writ. But the writs he issues are issued in French. But because it's Norman French and legalese, they look like Latin. So the writ that William loved enforcing the most was the writ of quo warranto. So he would find a man who was occupying a plot of land whose name was not on the Domesday Book, and then look at it and issue the writ of quo warranto and say, show me by what warrant, on whose authority are you holding this land? And if he couldn't satisfy the warrant, as in the writ wasn't satisfied, the crown would take control of the land, which means that the crown is the primary landholder in England at this point of time. In 1166, one of William's successors, Henry II, created the Assizes of Caldron. Now, the Assizes of Caldron are mobile criminal courts that would travel across England and Wales. Now, they're important because they restored the system of a trial by jury, right? So a person would be presented before the Assizes and would be put on trial. Then the jury would deliberate. Now, this jury was ideally supposed to be considered of 12 knights or 12 freemen of the 100. The 100 is important because the 100 is the subdivision of the shire, and the shire is what is your district in India there, right? The head of the shire used to be called a sheriff, and a group below that of the 100 used to be called the bailiff. So you would have a sheriff and you would have a bailiff. You would find that the bailiff's courts would continue to function through the Norman administration, but post 1215, the Magna Carta is issued, and the Magna Carta creates something called the Court of Common Pleas. Now, these are distinct. So, whereas before the Assizes, it would be the crown who would bring an action against you. Before the Court of Common Pleas, people could bring actions against each other. So, the 1215 Court of Common Pleas for the next 800 years would be not 800, 500 years would be the closest thing England really had to a civil court. So you would bring civil courts here. Now, a lot of your modern legal instruments originate as actions before the Court of Common Pleas. There's a typo in my presentation. I'll correct it and send it. Now, let's finally get down to India, right? Multiple legal systems existed in India between this period of 1772 and 1857. Aurangzeb, who was the Mughal emperor, tried his best to codify the laws of the Mughal Empire via the Fatwa-e-Almagiri. Remember, I explained to you back how Mughal emperors would issue multiple firmans and things like that, right? So this created a lot of legal uncertainty. So Aurangzeb, like a lot of emperors who come after a succession of great emperors, right, like Justinian, realized that he needed to consolidate this thing if he actually had to govern and administer this country. Now, Aurangzeb's rule is controversial in India. Some of us think he's a bad emperor, some of us think he's a good emperor, some of us don't really care about him because we lived in the south. But the broader thing we need to understand about Aurangzeb is that this Fatwa-e-Almagiri was supposed to be the codex for the Mughal Empire, what the Codex Justinian, Corpus Juris was to the Eastern Roman Empire. Aurangzeb tried to do with his fatwa to India. This fatwa was created, but no Aurangzeb after that. He was the last Mughal emperor to wield any effective authority throughout the territory of India. The Mughal Empire would collapse after Aurangzeb, and India would be run by a tea company. The East India Company was incorporated by a charter issued by Elizabeth I of England. The company, unlike most corporations today, also possessed a sovereign personality. Like Parliament had conferred on the company the right to conclude treaties and maintain armies, right? The company would have factories. The first factory, however, was at Surat. But the three most famous factories of the company have now become three major metropolitan cities in India. These were Bombay, Calcutta, and Madras. Now, here's what you have to remember, right? There is territory that the British conquered, and then there is territory that the British settled on in India. When Bombay, Madras, and Calcutta were given, right, this was unsettled land with very few local inhabitants in those territories. So England, it was as though all of English law arrived in these three cities on that date. So these were sovereign territories of England. So all of the law of England automatically applied in these territories. And the people in these territories were British subjects in these cities, not the presidencies. This further becomes important, right? Were British subjects and subject to British law. And as a result of this, what you have is you have three unique common law places in India that are developing right now, simultaneous with all legal developments happening in England. Okay, there was a lot of conflict. It's only about till the 1800s to be resolved whether a local legislature could overrule an act of parliament in England, whether local law conflicting with English law. So these are important things to understand again in the development as to what these three cities were, right? The second thing is that after this, through holdings and a series of wars, the East India Company takes control. So now there are three parts to the legal system to understand here. The system in the towns was the laws of England, and the courts function under the authority of the crown. Outside the presidency towns, in the territories of the company ran the court system but administered the law that existed before the company took over. And outside the territories of the company, the legal system was the legal system that existed prior to English intervention. Okay, so if I am in a presidency town, if I'm in the town of Bombay and I have a contractual dispute with another person in Bombay at that point, I go to the Crown Court established by the Crown of England and make my claim under English common law of contract, right? But if I am a resident of the territories of the East India Company, which are the territories and the presidencies, right? I go before a company court established under delegated authority given to the company by the British Crown, and the company court would have a Qazi or a Brahmin priest who would look at the dispute from the traditional law that applied to me under the Mughal era, and then based on this advice would come with a judgment. Now, this was always tempered by the constraints of justice, equity, and good conscience, which were exercised by the crown courts, right? But what you see here is, you see now is what scholars start calling the Anglo-Mohammedan law or the Anglo-Indian law, right? Company courts and crown courts found themselves in major conflict all the time. One great conflict like this is what I'd like to talk to you about is in the next two slides. I want to talk to you about how this legal system was used in India. This is the right of sati case. After this, if anyone's interested, drop me a mail and I'll send you the judgment. I have it. So Bentinck banned sati in Bengal in the year 1829. And by 1830, it extended to Madras and Bombay. In 1831, a group of Hindus from Bengal, Bihar, and Orissa moved the Privy Council challenging the Sati regulation of 1829. They said that the regulation was outside the scope of the East India Company's powers, saying that the East India Company, being a creature of an act of parliament, was limited by the powers in that act, right? So what these guys basically argued before the Privy Council was that matters of religion, right, were outside the scope of the powers of the East India Company, right? And that the Governor General had not considered evidence before passing it. But the company, what it did was it came before the Privy Council and it said that no, I have a general power to do this. Now the judgment is not very detailed because old Privy Council reports aren't very detailed. You just capture the arguments and then the decision. But the board dismissed the case. The board basically said that its advice to the king was that this case ought to be dismissed. But this is, as far as I know, India's oldest constitutional case. It comes from 1831. In which we look at our government and say our government is limited by an instrument and this government is exceeded the instrument. And if you look at the grounds that we raised today, we still say it's outside the scope of your powers and it's unreasonable and you haven't looked at the evidence. These are the same tests we use to challenge legislation today or regulation today. This was done in 1831, though for a cause that I do not support whatsoever. I think these people were basically horrible people to try and stop this law, but this law did come into force and sati was banned. And it was held to be constitutional. So it's not like Indians have not challenged legislation in the past. The second interesting thing is this case of Moro Raghunath. Now, Moro Raghunath is another very interesting case because this case directly deals with the conflict of the powers of the company and the conflicts of the courts of the crown. Now, I'll capture the facts of the slide. The dispute basically deals with the custody of one Moro Raghunath, who was a 14-year-old boy. Now, the company basically had kept him happy in Pune and given him to a guardian, right? Now, one person or a relative of his felt that he was being mistreated. So through his lawyers, he applied to the Crown Court in Bombay, which was now called the Supreme Court of Bombay by virtue of the Regulating Act. He applied for a writ of habeas corpus, which is that saying that Moro Raghunath is being unlawfully detained and he needs to be put somewhere else. The court issued the writ. The two judges, Chambers and Grant JJ, issued the writ of habeas corpus. The company, though, refused to enforce the writ, saying that the jurisdiction of the Supreme Court of Bombay was limited to the town and island of Bombay, but was not extending to the presidency of Bombay. Now, obviously, Justice Grant at this point said, no, nothing doing. My jurisdiction goes because I'm a crown court. I can do what I want. So, in protest, Grant J basically locked up the room of the court at Admiralty House and took away the key and went and sat in his house. He said that the court would not function because Chambers got recalled. Grant was the acting CJ at Bombay. He basically said the court in Bombay would not function because its orders were not being enforced. It didn't make sense. Now, this created a huge conflict between the executive and the judiciary in India. Messages were sent by the Secretary of State for India. The company basically said that if the courts say that their jurisdiction extends to the entire place, we will no longer be able to effectively administer this country because every treaty and relationship would then be called into question. Doctrine of displacement, right? English law doesn't apply outside Bombay because unless the company says so. So this matter finally went on appeal before the Privy Council. Now, the board always sided with the company back then, and after a while started siding with the colonial government. It wasn't a very fair board. Even though in the 20s we had an Indian on the Privy Council has always been a little biased towards India. There's a lot of hatred felt by Indian historical personalities to the board because the board never did complete justice as our Supreme Court does now. But that being said, the Privy Council said the writ was not maintainable. Grant J said, fair enough, if my writ is not maintainable, I have no grievance. He opened the court. But these are major fights that happened in that time, and this is something we need to remember. In 1857, Queen Victoria became Queen of India. Right? Victoria issued a proclamation saying that the company's rule in India would be transferred to the crown. Our history books in civics often stop at this which is sad because the next year, what happened was the Government of India Act of 1858. It created a guy called the Secretary of State for India, who was officially the British government's arm in India, and a Viceroy and Governor General in India who was responsible for administering India. Like, India would still be controlled by the British government, but the administration of India was supposed to be done for the benefit of India from 1857 onwards. And a wonderful thing about this was a separate budget was created for India. India was to be run on the basis of Indian tax revenues, and all tax revenue raised in India was to be spent for India. So this idea of India having to make payments to Britain, right, is a far more complex thing because India didn't have to make payments from 1857 onwards, and even before then, it was the company's profits that were being transferred to Britain. If you look at the British parliamentary debate, as in the debate in the House of Commons over the passage of the Government of India Act of 1858, is that you will find the biggest critique of the company's administration in India came from the British. Like this, there is scathing critique by Disraeli and Burke about the atrocities committed by the company in India. They felt that this company was capitalism gone mad. They needed to take it into control, and they took it into control and effectively ruled India. The argument was that we could just walk away from India now, but the company has done so much damage. There is no government here because they destroyed the Mughals and the Marathas, right? There was no government. India would fall into anarchy, chaos, and civil war, so they stayed, but they didn't profit. As in, not directly. Indirectly, obviously, politicians find a way to make sure their vested interest groups will profit, but at least on paper, from 1858 onwards, everything that was raised in India via taxation had to be spent for the benefit of India. If India had to give money to support England during a war, it was a loan. There was interest that was charged on that loan, and that loan would have to be repaid. If you look at it immediately after independence, we have an agreement that we've concluded with the United Kingdom to talk about the war debts that the UK owed India during World War II. That's a different thing, but this is important. 1857, the Government of India Act 1858 is what I personally would call the first modern constitution of India. This was followed by three Government of India Acts. The Government of India Act 1909, often called the Indian Councils Act, which allowed for limited participation by Indian inhabitants in their own governance. Now, look at the timeline. Of course, there were some Indian members in the Viceroy's Council, Executive Council before, but the idea of elections of these members and the increasing participation of Indians in their government is something that you see develop over a course of a series of Government of India Acts. Okay, so just because I'm saying I'm listing four here doesn't mean there are only four Government of India Acts. There are many Government of India Acts, and each Government of India Act had its own unique thing. So now, the Indian Councils Act of 1909 gave us finally a role in the administration of our government. The 1919 statute established a federal character in the country, and the 1935 Act was the supposed independence constitution. This was supposed to be a framework for a free India in a phased manner. The full Act never came into implementation. Elections were held under the Act, but everyone resigned in protest in 39, except for the Muslim League, after the Viceroy declared war on Germany. But 35 Act is important because provinces were largely functionally independent under the 1935 Act. So provinces could basically do what they want. Yes, they were elected by limited franchise, but they were functionally independent. The viceroy still had some reserve powers on ecclesiastical, budgetary matters and things like that, defense especially, but viceroy and governor general. But the idea was with the 1935 Act was that all the princely states would join together and apply. So the idea of an instrument of accession comes in the 35 Act, right? So any Indian princely state could make by an instrument of accession join the 1935 Federation Constitution. And the idea was that a federation of India would emerge and slowly that the British would release these powers. Now, obviously, the war happened in 1939, war broke out, which put a stall on most things. But initially, a lot of Indians rejected it, but we participated in the elections that were conducted under this act. And a lot of provincial governments were created. And these provincial governments are powerful under this act, but they're still under the overall control of the center, a feature that we see translating into the modern constitution of India, but what I will discuss hopefully in another webcast. All right. So the 1935 Act is also interesting because you establish you see functionings of two houses of parliament. This has happened after its move to Delhi. So you see the Indian legislature meeting at Sansad Bhavan. You see the viceroy residing at Rashtrapati Bhavan. There's the imagery that we understand as far as civics in India comes. You've got a federal court that acts like your Supreme Court, though still in some cases appeals could go straight from the High Court to the Privy Council. But the federal court would largely resolve these questions. And if the federal court granted you leave, you could go to the Privy Council to appeal against the decision of the Federal Court of India. Now, this becomes fun during 1939 and 1945 because India is at war then. The draconian Defense of India rules are in place. Right now, we feel as though we are in wartime because of the pandemic, but a lot of these measures you see right now are there already in the Defense of India rules, as in the sheer power that the executive has when it needs for the defense of India. But what you see is you see the federal court, right, granting a lot of habeas corpus motions during this period for people who were illegally detained, only to have that overturned later by the Privy Council in England, right? But the reason I'm stressing on this is this. There are courts in this country today who are saying that time is not conducive for law. British judges during the Second World War in India heard habeas corpus applications. All right. What I'm trying to say is that what we are seeing now is something unthinkable, to actually hear a court say that things are not conducive to affect the law, because the very idea behind the common law in India is that the law reigns supreme. There is never a time for there to be no law. The law cannot be suspended under any circumstances, right? Because even the crown rules under the authority of law. But this is a digression again. All right. So now let's come to the codification and transposition of English law into India. So this is a statement that Lord Macaulay made to the Indian law commissioners. Now, even before 1857, there was a commission, law commissions that were created for the laws in India. The Sati Act, for example, Regulation Act, is one of those things that comes from the law commission. The idea behind this codification was to solve this problem that arose from Moro Raghunath's case, right? Which you saw, sorry, in the case of Moro Raghunath. What happens to company territories that are being run by company courts? Isn't there so much chaos? We need a uniform system of law, right? So the Indian Penal Code, in its draft, was always called the Uniform Penal Code for India, right? And Macaulay develops this, and Macaulay also pointedly in this statement in his report captures what he felt were the fundamental problems in the system that was prevailing at the time, right? Like how a Muslim under the Muslim law is treated differently from a Hindu under the Hindu law, and how some acts are crimes if you're only some people, and some acts are not crimes if you're some people. I mean, this is chaos, right? So the idea was to prepare a uniform code. Funnily enough, Macaulay was not a lawyer. Macaulay was actually a writer. He's a very good writer in the English language, and some of his work is fantastic, and I would recommend that all of you read it. Some of his works. So he prepares the penal code. Now, the beauty about the Indian Penal Code of 1860 is you have to understand the legal philosophy at the time. Macaulay wants to capture common law concepts, but wants to codify them. Right, even the British didn't have written criminal law there. I think today, even till today, theft is proved by a case law in England. All right, there's no theft act, right? And murder becomes a statutory offense only with the old offenses against the Persons Act, which are all based on this uniform legal code that they prepared for India, right? So they sat and looked at the law of England. They tried to codify it and temper it to suit Indian sensibilities. So there is one unique offense that you will find in the Indian Penal Code that you may not find in the laws of any other countries. One of these is called the offense of divine displeasure, okay, which says that if somebody convinces you to do or not do a thing, saying that if you do or not do it, if you don't do what they're asking you to do, you will become an object of divine displeasure. They have committed an offense in India. So if a godman comes and says you have to, kill your mother-in-law, otherwise God will hate you, that godman has committed the offense of divine displeasure. Now, this is an offense that is unique to India. Another fun offense that is unique to India is thuggery. Yeah, there is if you are a thug, you have committed an offense. You will be subject to imprisonment and fine. So that's the interesting things. But otherwise, the common law definitions of murder, right? Of what is murder, what is culpable homicide, when does culpable homicide amount to murder, when does culpable homicide not amount to murder, right? Uh, right? As Bhairav has rightly pointed out to me in the chat, it's section 508 IPC. Yes, it's a classic offense. Yes, I'm glad people are enjoying this. But yeah, so what is murder? What is culpable homicide? All of this, right? For example, the culpable homicide not amounting to murder is a very modern legal term, because the traditional legal term is actually manslaughter, which is something you do not find defined in the IPC as manslaughter, but it's culpable homicide not amounting to murder. Right. So that is the scientific principle on which he does it. He also applies a lot of modern science to how punishments are done. So back in England during this time, and at least till 20 years earlier, right, this is in 1837, right? If you stole more than 20 shillings, you could be sentenced to death. Children who showed devilish intent could also be sentenced to death. This was called the Bloody Code. Parliament's view was the only way to reduce crime was to increase the punishment. This didn't work. All right. So when we see people trying to propose that today with the expansion of the death penalty, I am like, guys, have you looked at your history? The whole reason we have the penal code with limited death penalty offenses is because we saw through our collective global history, right, that this idea that increasing punishments will deter crime does not work. As in, it does not practically work. It has no, but forget that. So if you read this report, and I recommend every law student and every lawyer read this report to get a thorough understanding of IPC, right, is fundamentally so you understand why certain things are punishable with fine, why certain things are punishable with imprisonment, what is transportation, and why is that considered life imprisonment even though transportation no longer exists here, right? Understand what is simple imprisonment, rigorous imprisonment, why is he prescribing some things, why are fines not income tested? All right, all of this is discussed in that report. So the first major English law to come into India was a reform of the criminal law. And this happened in 1860 when the Penal Code was finally enacted by the Indian Legislative Council for India, Viceroy's Council for India. The Indian Penal Code came into force in 1860, and for the first time, all of British India, remember, no princely states, British India, because now the distinction between the presidency territories and the towns was also gone, was brought under a uniform system of criminal law. All right, and this is important because with this you also came the procedural laws that came. All right, now for me to explain this, I would like to one second. Sorry, my slide is just coming back up online. From current slide. This is the last slide in my presentation, so that's why it went straight to the edge, I guess. So I'm just sharing this now. You will now see my screen. Yeah, here you go. I hope you guys see the screen. Great. Now, this is the last bit, and this is where I think I will sum up this thing, right? What is displacement? How does it work? And this is why I wanted to give you a historical introduction. There is no law. Then there is law. Then when the new king comes in, the previous law continues to be the law till the new king says no. Right? So the new king can say no to half the law and keep some of the law. The laws that the new king changes displace the previous law. So when you enact the Indian Penal Code and the procedure for trying offenses under the code, what you do is you displace the law of crime that existed earlier. You displace the Hindu law of crime, you displace the Muslim law of crime. So now in India in 1860 onwards, for the first time, killing a Brahmin is the same as killing a Dalit legally. If a Brahmin killed another Brahmin and a Brahmin killed a Dalit, or a Dalit killed a Brahmin, or a Dalit killed another Dalit, they would have all been covered under murder and they would all be punished the same. It is equality that flows from something like this. And second is what you also understand is with the British administration, fundamental common law as things start coming in, right, from 1857. So wherever the Mughals had not spoken about it, or the Hindu kings who were there at that point had not spoken about it, or there wasn't some company regulation, there came the common law with the common law courts administering wherever there was silence with law, justice and equity. Justice and equity where there is no silence, when there is silence in the law. What does this mean? This means that your offensive defamation, as originally defined in the IPC, had free speech exceptions. Almost every speech offense that was defined in the original IPC presumed you had a freedom to speak and then had exceptions for fair comment as enacted. Sedition, for example, was not an offense in the original 1860 code, because it felt that the law of England meant that all of us being British subjects had certain fundamental freedoms. These freedoms need not have been written down anywhere. Queen Victoria's proclamation of 1857 prevented discrimination on the grounds of religion, barred the state from establishing religion, and further said that all natives would be treated equally with European subjects, which meant that Indians would join the civil service. Now, this is equality. This is 14. This is Article 14, Article 19, right? And due process comes from Magna Carta. Right, so 14, 19, and 21, your right to life, equality, and liberties, right, find their place in English common law and are there in India in 1857. I say, and before that, you have seen people petition for habeas corpus. So one of the reasons I wanted to talk to you about all of this is that today we are finding a situation in the country where we are equating constitutional with right and unconstitutional with evil. That is not the case. This is just the Constitution of India of 1950, right? But there is a broader legal tradition that backs up our liberties, and this comes from the common law. So my right to freedom of speech is recognized by Article 19. Article 19 does not give me the right to freedom of speech. I have the right to freedom of speech by virtue of being in India. This is important for us. This is an important distinction to make. So you could have so this results in sometimes the most evil of propositions being constitutional, but whereas the most nicest of things would be unconstitutional. So when you look, so when we're discussing this thing like NRC, CA, right, make sure, you will consciously be sure that we do not conflate legality with morality. What is moral is often not legal, what is legal is often not moral. that shouldn't prevent us from morally critiquing the law. So if someone comes and says that something is good because the constitution allows it, well, the constitution says that unless parliament makes a law on this, marital rape is also legal, effectively, and it doesn't say so explicitly. But marital rape being legal in this country does not mean it's morally right, right? So this is how I would like to conclude this. So, uh, so how I would like to broadly conclude this is with this, right? Look at Ayodhya. Ayodhya is a classic example of how these various historical systems are intersecting. In Ayodhya, one of the plaintiffs was the idol of the Lord Ram. Now, the juristic personality of an idol is something that has long been recognized in Hindu law. The idol is the owner of the temple, and the priest is maintains the temple in trust for the idol, right? So it's called the Shabayat. Now, Shabayat again is a Persian concept that comes later. This concept was recognized by Mughal rulers and was not displaced by them and was not displaced by the crown in India. So, largely, what I'm trying to say here is that in Ayodhya, you'll find a classic example of these various levels of displacement that have happened over the last couple of thousand years of Indian history. And that's about it. So you find a lot of displacement happening in the law of crime. You have a law of contract, which is displaced with the Indian Contract Act. You have the law of trusts. But strangely enough, the law of trust does not apply to religious and charitable endowments. So Hindu charitable trusts continue to be governed by special acts established in some states, but where in some states they don't, they still tend to be covered by traditional Hindu law. You'll find these cases of majorly appearing when it comes to cases regarding how do you appoint a priest, who has the authority to appoint the priest. Muslim mosques continue to be governed by waqfs, AKF. Waqfs have been recognized. So your personal laws, for example. So to say that the law of India, so to say something to, so coming back to my first thing, which I started this class with, is if you're going to say India is a common law country, you're wrong. If you're going to say India is a civil law country, you're wrong. If you say India has customary law, you are wrong. India has a unique legal system, and all of these legal systems culminate with an end in this era of history. Because the post 1950 constitution development of the legal system is far more complicated, because there are some very open questions about the constitution of India, philosophical and legal questions. Now, I'll discuss these open questions at a much later date. But this concludes my presentation, and this concludes the large operative portion of this class. If you guys have questions, now would be a good time for you to ask me these questions. So type a message in the chat, and we can see these questions. So I'm going to leave the floor open for questions for about 5 minutes now. So if you guys have any questions, let me know, and let me also see if I can send everyone the PPT. I don't really know how the Zoom works. Yeah, okay. No, my file is still here. Yeah, I'll have to close PowerPoint to share the PPT. Yeah, close PowerPoint. All right, PowerPoint is closed, and I have sent the PPT to everyone. So PowerPoint is closed. I've sent the PPT to everyone. So if you have a question, let me know right now. I'll be more than happy to answer questions right now. So thanks for your nice comments, everyone. Isha, if you could just tell me what you missed, I can cover that again. Wait, let me just unmute you. So you can ask for everyone. Hi, Isha, tell me.
Hello.
Hi, Isha.
I just everything, the moment you mentioned NRCCA, there was a major audio problem. I'm not sure whether everyone else also experienced that. So if you could just repeat what you said at that time.
All right. So what I'm basically trying to say is that towards the end of my presentation, what I was trying to say is when you have NRC, CAA as being topics of discussion, right? It's very easy to get confused that just because something is constitutional, it equals morally right, or just because something is unconstitutional, it becomes morally wrong. right? The constitution is a system of laws, not a system of government, not a system of morals. That's one. And the second thing I wanted to say was this merely because something is constitutional does not mean you can't critique it morally. So you're open to the moral critique of it. And the last thing I was talking about was that to understand that India's legal system is very complex. You cannot just simply call us a common law country. You can't call us a civil law country. You can't call us a country governed by customary law. India's system is quite fun and entertaining and ridiculously interesting, in which you will find sources of law going back to Shastras that are quoted in court and things like that. Despite the number of years of English common law, we still say, we have this colonial hangover, right? But when we go into court, we file something called a wakalatnama, which is a Persian term, which reminds you of a Mughal period. So Indian lawyers and people who interact with Indian law are inheritors of a very old tradition. And merely because the tradition exists doesn't mean that we can't critique it. So if someone says, this is good and this is not morally wrong because it's constitutional, well, tell them to take a hike. A lot of morally wrong nonsense is constitutional. A lot of morally right things is unconstitutional. Morals has nothing to do with it. So that was the last bit I wanted to talk about. All right, Flo, for any more questions? Come on, guys. I just gave a lot of nonsense. I want some questions. Yeah, challenge me on something. All right, so my next class that I'm planning to do, because I'm glad at least 20 people signed up for this, it made it worthwhile, uh, is I am thinking of doing a introduction to Constitution, but unfortunately that'll be very difficult to cover in one lecture. I'm thinking maybe 4 lectures we could do Constitution, yes, and what an average Indian needs to know about their Constitution. I hope you enjoyed this, and I will be posting on my Instagram and Facebook about the next time I'll be doing this. Chalo, good night, everyone. Cheers.